the Senate's back in session in another hour. And so what we have today, we're very honored to have her Tech Policy Counsel, Connor Glisson, will discuss artificial intelligence and other tech policy issues on her behalf. I just want to tell you a little bit about Senator Blackburn, and we hope to have her back here at Hudson soon. She's from the volunteer state, which is just, a volunteer is just a euphemism for a fighter on behalf of other people. Throughout her career, she's been a fighter for various American values. She's been a fighter for property rights, for intellectual property. She's been a fighter to protect American children. She's been a fighter to protect small businesses from the encroachment of Washington bureaucracies. And she's been a fighter staying up very late this morning, and we look forward to having her back here at the Hudson Institute. It's my honor to welcome Connor Glisson, who is her Tech Policy Counsel, who will be speaking about artificial intelligence and other topics. Mr. Glisson has a distinguished career in the telecommunications sector and now has the great honor of working for Senator Blackburn. Mr. Glisson. Thank you.
Good morning, everybody. Senator Blackburn, like Dr. Furchtgott-Roth mentioned, sends her regrets, but would love to be here with y'all in the future. So thank you for inviting me to discuss some of the tech policy issues we're addressing this Congress, including artificial intelligence, data privacy, and children's online safety. To start off, I'd like to table set the issues around the 10-year AI moratorium. As many of you saw during the voting process for President Trump's One Big Beautiful Bill, the Senate struck the moratorium on state AI laws with a resounding 99-1 vote. In Washington, it's rare to see Republicans and Democrats unified on any one issue. But in this case, the upper chamber came together to ensure that states can continue to protect their citizens from the unintended harms of AI. This was a huge win for families, artists, and our nation's federalist system. To be clear, AI has the potential to transform entire industries with new innovations. In healthcare, it can improve detection, treatment, and post-op care. In manufacturing, it can increase efficiency, lowering costs for consumers. With farming, it can improve yields by identifying pests, tracking soil conditions, and improving water usage. At the same time, however, AI poses serious threats from intellectual property theft to the AI generation of child sexual abuse materials. For years, though, Congress has failed to pass national standards for the virtual space. When Senator Welch and Senator Blackburn were on the House Energy and Commerce Committee more than a decade ago, they worked on bipartisan legislation to establish comprehensive data privacy. Big tech fought them the entire way on it. They never got a vote on it, and Congress still hasn't gotten its act together. Instead, state governments across the country have been standing in the gap to protect Americans from harm. Just last year, Tennessee enacted the Elvis Act to protect musicians from having their voices and likenesses used in AI-generated songs. This measure is especially vital as AI threatens to cut artists' incomes by a quarter within the next 4 years. Recently, Utah became the first state in the country to enact an AI-focused consumer protection law requiring transparency and accountability from companies that use generative AI. Under Governor Sarah Huckabee Sanders in Arkansas has led on responsible AI governance with new laws that protect residents from copyright infringement and the generation of child pornography. In many cases, states are modeling protections for their citizens off of legislation that has not yet passed through Congress. That's exactly what Tennessee did with the Elvis Act, which is based on the No Fakes Act that Senator Blackburn, alongside Senator Coons, Tillis, and Klobuchar, have led. An AI moratorium would have decimated these protections, as well as safeguards enacted by more than 24 states within just the last year, without providing any federal measures to replace them. For Congress, the path forward is clear. Instead of passing a moratorium, we must finally pass federally preemptive legislation that establishes national standards for AI. That way, we can eliminate the state-by-state patchwork and ensure that America leads in AI development, while still shielding Americans from its harmful consequences. To protect artists, musicians, and creators, Congress must pass legislation that protects individuals' voice, image, and likeness from AI abuses. The bipartisan No Fakes Act, which I just mentioned, would hold offenders legally liable if they distribute an AI-generated replica of an individual's voice or visual likeness without their consent. This is a necessary protection for the American music industry, which supports more than 2.5 million jobs, many of those in our home state of Tennessee. It also protects everyday Americans from the reputational harm of having their voices used in fake recordings and videos. Alongside Senator Blumenthal, Senator Blackburn also reintroduced the bipartisan Kids Online Safety Act, or KOSA, which would require common sense protections for children in the virtual space, including from predators who use AI to generate sexual abuse material. This legislation passed out of the Senate 91-3 last year, and we are working closely with our House partners to ensure that it gets across the finish line and sent to President Trump's desk. It would create a duty of care for online platforms to prevent specific threats to minors, including sexual abuse, illicit drugs, and the promotion of suicide and eating disorders. This duty of care would only apply to product features like algorithms, not content, meaning KOSA would safeguard free speech while protecting children online. In many ways, KOSA is just common sense. There are many protections for children in the physical world. For example, they can't walk into a strip club, they can't purchase alcohol and tobacco in a liquor store, but in the virtual space, they can access all of these harms and more. Congress must also finally pass a national data privacy law that protects Americans' virtual you. As AI models collect more and more personal information on users, from location tracking to search history monitoring, this issue has taken on even greater urgency. That's why in the Senate, we are focused on getting a comprehensive data privacy bill to President Trump's desk as soon as possible. As a first step, later this month, the Senate Judiciary Subcommittee on Privacy, Technology, and the Law, which Senator Blackburn chairs, will host a hearing exploring how a national framework will protect personal data across state lines, empower consumers, and encourage responsible innovation. Senator Klobuchar is the ranking member of this subcommittee, and we are working closely together to address this problem once and for all. When it comes to AI, these are just a few of the issues lawmakers will have to address. Thankfully, state governments across the country have been hard at work crafting solutions. As Congress works on national standards, we are fortunate that we can learn from them. Another bill that we're working on right now is the Open App Markets Act. And this is another issue that Congress must address, preserving competition in the apps marketplace. Right now, with their app stores, Apple and Google have a stranglehold on the market. With Apple devices, you cannot put something on your phone that does not go through the Apple App Store. Although Google is less restrictive with Androids, it is still very difficult to put third-party apps on their devices. While serving as gatekeepers, Apple and Google force startups to fork over 30% of their profits. This is not just an issue of market efficiency, it is a matter of protecting fundamental freedoms. After Elon Musk acquired X, Apple threatened to ban the social media platform from its app store. In China, Apple and Google have banned users from downloading apps such as VPNs that would allow activists to circumvent the CCP's strict censorship. Recently, Senator Blumenthal, Lee, Klobuchar, Durbin, and Senator Blackburn reintroduced this act, the Open App Markets Act, or OAMA, to address this problem. This legislation would set fair, clear, and enforceable rules to protect competition and strengthen consumer protections within the app market. Among its provisions, it would protect developers' rights to tell consumers about lower prices and offer competitive pricing, protect sideloading of apps, and open up competitive avenues for startup apps, third-party app stores and payment services. In closing, I want to thank you so much to the Hudson Institute, the Center for Economics of the Internet, and Dr. Furchtgott-Roth for your leadership on so many of the issues, and thank you so much for having me.
Well, thank you, Connor. Those were wonderful comments. Pinch hitting at the last minute for the good senator. You mentioned 4 specific pieces of legislation that Senator Blackburn's working on. AI, privacy, COSA, and this Open Apps Act. Could you give us a little bit more detail on where they are in the legislative process right now, and which of these do you hope to move first?
Sure. I think most likely we're looking at the No Fakes Act. We're pushing towards a markup on the Judiciary Committee. We're kind of working through a few last edits, a few last tweaks with a couple different groups. Because I mean, with anything that's comprehensive, we obviously want to make sure we think through every possible business model and every possible scenario as not to unfairly harm a particular business model just by an oversight. So we're getting close on that one. The Open App Market Act we introduced it, again, hoping for a markup sooner rather than later. And then also at the end of the month, like I mentioned, we're going to start a series on protecting the virtual you on Senator Blackburn's Privacy, Technology, and Law Subcommittee on Judiciary. First, we hosted one on AI deepfakes, kind of centered around the No Fakes Act, and that would protect individuals' name, image, and likeness from AI-generated harms. We had Martina McBride, who came in and told some stories about some of the harms to her and her artist friends. But this next one is going to be focused on the priorities surrounding a comprehensive privacy legislation, and I'm excited about that one.
You all should be preparing questions, and for our online audience, please send those questions. What's the right hashtag to send questions in online? Talia, what's the right question to send questions in online? Let me just ask a couple more questions, and I'll turn over to the audience for Q&A. Right now, a lot of privacy activity online, privacy regulation is being led by the European Union and GDPR. And then we have just about every state has a privacy law. So there's this quite a patchwork quilt of privacy laws. Frankly, my sense is the EU has a lot more leverage than the states do. How do you see that playing out? How do you see federal privacy legislation working in this already highly complicated regulatory environment?
Right. As you mentioned, I think every day that goes by, it becomes more difficult to get something comprehensive and preemptive at the federal level, just when you have to deal with more and more patchwork, as you mentioned. But I mean, I think we kind of have to look at what's out there, what's working, kind of as states are a test bed for democracy in a lot of scenarios. So I think we can use some of those as examples of what we can look for next. But I think also something to consider. I remember a senator years back in a hearing gave an example of two individuals walk past a Starbucks and get a notification on their phone that says 20% off your next latte. One person is excited about it, walks in and buys their drink, says, "Oh, this is great." Next person is upset and bothered. How do they know where I am? How do they have my information? So I think we have to be able to reconcile both of those views on privacy, whether that's geolocation data or just any kind of personally identifiable information of what these data controllers and processors can do with that information. So I mean, we definitely have our work cut out for us, but I think it's something we can achieve.
And what is Senator Blackburn hearing specifically from the good folks in Tennessee? Is it, which of these issues is upsetting the good folks of Tennessee the most, would you say? Is it AI? Is it privacy? Is it COSA? Which of these is her office hearing the most about from folks in Tennessee?
I think given the significant and sizable creative community we have, particularly in Nashville, with musicians and artists and everybody in that group, I think the concerns around AI, generative AI, copyright issues, the ability for these large language models to come in and train on copyrighted works without having an agreement in place to compensate the artists. I mean, it's going to be a fundamental shift in kind of in the way we view things. I mean, this is written into the Constitution for protections of IP, IP laws. So I think that's something back home we're seeing a lot of concern around.
Let me open it up to questions from the audience. And we have a microphone. Please identify yourself when they come in. And I also would like to welcome our C-SPAN audience. We're very happy to have C-SPAN today. Please, over here.
Hi, thanks for being here. I'm Daniel. I work downtown. I just want to ask, I want to say Take It Down was a huge success. I know the senator was very happy about it. President Trump signed into law. Can you just give a little bit more granular detail on what COSA seeks to address that Take It Down did and sort of what the distinction is? I know a lot of people are want some more granular detail on that. Right,
yeah. I mean, COSA is going to take a more comprehensive approach to kids' online safety. Yeah, I mean, it's a large bill addressing many things within the kids' online safety area, from algorithmic harms to CSAM material, check children's sexual materials. So yeah, I think it just takes a broader view of it.
Joseph Schneider, thank you very much, sir, for this informative talk. And my question relates to the Open Up Markets app because it emphasizes interoperability between apps and platforms. And I know that the European Commission did something similar some years ago regarding phone chargers. And so I would like to ask you, obviously, we know that this is a more democratic process, whereas the European Commission is more unaccountable to the people. So where do you draw the line between forcing a fair market but also being more accountable to the people?
Right, man, I think it's a fine line we have to walk. I mean, the market power that some of these tech companies have achieved, I mean, I think it's fair to say they rival that of governments in many scenarios. So I think we have to kind of get past the notion that just because it's a private company doesn't mean you can't regulate them in some capacity. I mean, if they're causing market harms, I mean, that's an opportunity to address it.
Hi, I just want to clarify first, I have a speech impediment, so it might take me some time to get my thoughts out, but we will get there. I'm Molly from those Media Alliance, and something that I think we're kind of seeing across like the data privacy bills and different states is I think we're seeing a lot of pushback in terms of in New York the push for companies to have disclosure notices like pertaining to consumer data use. Like there's currently a lawsuit in New York right now that's saying those kind of disclosures are compelled speech. So like a First Amendment violation. And so I guess my question is like, is this kind of contention point with data privacy laws something that your office is keeping track of? Thank you.
Yeah, I mean, it's certainly something we're going to have to contend with as we work through this process. But I think also, like I mentioned previously, that states are oftentimes the test bed for democracy. So I think that's something we can certainly learn from, see how the courts are ruling on those, as we work together to bring federal stakeholders together to make sure we can put forth the best standard for the nation.
Along those lines, and thank you for the question, when I teach communications law, I always pull up the Google terms of use. I think I'm probably the only person who's ever read them. But they're actually they disclose everything they're going to do, and that they're going to keep all the information. And so disclosure alone doesn't really, people don't actually read these notices or the terms of use. Is this something Senator Blackburn is focused on? Disclosure alone doesn't seem to solve a lot of these problems.
Right. I mean, I think it's important that there's clear disclosure, like you said.
Yeah.
I don't know if I've met anybody else who's made it through the entire Google disclosure list.
It's not that long, but
Yeah.
No one actually reads the terms of use, or very few people. Only
Right.
people in my class.
Yeah, I mean, I think whatever a private company does say that they're going to do, I mean, I think FTC Part 5, that's a FTC issue. I mean, something they should definitely go after. But yeah, I think that's certainly one component of what a privacy framework should, could, and will look like. But I think I'm actually also outside the privacy context. We're looking at in an AI context the same thing, because I know like the 16 frontier AI model providers in the U.S. have released privacy standards in some capacity, and potentially looking at codifying something around that to ensure that they're doing what they say they're going to do. Just kind of what their data use policies are, what they're going to do if some of these models achieve certain threshold capabilities.
Which, you're speaking about a fair amount of regulation and enforcement. Is a lot of this going to wind up at the Federal Trade Commission or other agencies? Right now, every federal agency has its own privacy officer, its own privacy policy, and its own data. How do you make all of that more efficient, and how do you see the federal government being efficient at looking at questions like privacy or children's online safety?
Right. I mean, I think we can take a lead from some of the things the White House is doing, taking a whole of government approach. I think we need to streamline things and kind of house things in one individual agency, I guess, for lack of a better way to phrase it. Because I mean, coming from the telecom side of the world, I mean, it was always a challenge to deal with 6 different agencies to be able to license. I worked at a satellite company to be able to get our satellite up. We had to deal with the FCC, we had to deal with NTIA, we had to deal with NOAA, we had to deal with Office of Space Commerce. And when you have to go to all those different agencies, I mean, just the efficiency goes out the door. And we certainly want to create an environment in the U.S. that is the leader in attracting this investment and kind of how we bring it back home.
Thank you. Rick Lane, CEO Iggy Ventures, but I also volunteer my time advising child safety groups on tech policy. So first of all, thank you and the senator and the rest of the staff for all the work you did on the AI moratorium. I know that was another late night at 4:30 a.m. for the vote. And I also appreciate Senator Blackburn's very broad view on how different pieces of legislation work together to help facilitate the protection of children online. So Take It Down is about deep fakes. The Kids Online Safety Act is about algorithms and ensuring that they're not used to create addiction. And then the No Fakes Act is even better because it allows children to have the protections if their name, image, and likeness is used to cyberbully them. Because the Take It Down Act only is about CSAM from a child safety perspective. And then, of course, the AI protection of copyrighted work. So yesterday, Senator Hawley had an amazing hearing basically saying that the collection and ingestion of copyrighted works without a license is criminal. And he had examples of what was happening at Meta. But one of the questions that I've had about this idea that you are able to ingest copyrighted works and that helps us compete with China in the AI race is, how is it that allowing Chinese companies like deepfakes and for the time being TikTok, hopefully that will change as well, but TikTok, how is that having unfettered access to US copyrighted works without paying a licensing fee, uncontrollable, help us as a country compete with China in an AI race where data and information is really the cornerstone? Wouldn't it be better in terms of beating China in the AI race to ensure that our copyrighted works are actually controlled by the copyright owners? And if they want to license that, that is a better way, because that way we have revenue coming into the United States instead of a massive theft, as Senator Hawley said, of our copyrighted works to countries like China, and that helps facilitate deepfakes and as well as DeepSeek and TikTok in their race to AI dominance.
I agree. No, I mean, I think allowing a lot of these AI models to be able to train on everything under the fair use doctrine is a short-sighted approach to it. I think in the immediate term that may, well, like you alluded to, I think people could argue that that would be beneficial in the short term. But I think over the long term, it's going to decline the quality of the work, decline the quality of the data, if there's no incentive for these artists to continue creating these high-quality works. And even outside of the artist and creative community to, I mean, professors and people writing textbooks and in any of these materials, I think if they're not adequately compensated, they're going to stop creating. There's going to have to be a different model for things. And I mean, Senator Blackburn has certainly been acutely aware of this problem for quite some time now.
Along those lines, on July 31st, it's called the International Trade Court is going to be hearing about the legality of President Trump's tariffs based on IEEPA. But the tariffs could easily be based on IP infringement, particularly with respect to China. Is Senator Blackburn looking at tariff policies related to intellectual property infringement?
Mm-hmm. She's certainly aware of it, tracking it very closely. Our tax trade policy guy has say he's been one of the busiest guys in the office for quite some time on these issues. Yeah, I mean we're excited to see what comes out at the end of the month, and
okay.
Yeah.
Other questions? Yes, please. The last one was so good. Let's get another one.
Well, thank you very much. It's a high compliment coming from you. So COSA, the Kids Online Safety Act, obviously has strong support with the child safety groups, the parents groups, I mean, across the board, and you saw that in the Senate vote. After the moratorium vote, there was a statement attributed to House Republican leadership that because of Senator Blackburn's heroic effort of getting that moratorium out, that COSA is basically dead. Can you speak to that? And how do we, as child safety advocates, convince the House Republican leadership that this is such important legislation? And the second piece of that question is, on Section 230, there is legislation potentially being introduced that will sunset 230. Those two pieces together could really provide a tremendous amount of help to our child safety groups. So again, Senator Blackburn looking at all these potential issues, COSA and its potential in the House, also getting it through the Commerce Committee and where Senator Cruz is on that. And second, really fundamental is the sunsetting of Section 230 so it can be truly reformed so it's not having the harm that it's currently causing to children, especially at this time and in this age.
Right. I mean, Senator Blackburn is always, throughout the AI moratorium discussion, she's always been supportive of a federal framework to address these issues. She didn't have the confidence that Congress was there just yet. I mean, it's one thing to preempt states with a solution, but preempting without a solution is not a viable route. So I mean, I think as we work through COSA, AI legislations, I mean, I think that's certainly creating the opportunity for better protections for children online. And then I think the 230 issue is kind of a separate one. I haven't necessarily thought about it in the same context as with COSA. But again, yeah, I mean, it's definitely something we're paying very close attention to.
With that, please join me in thanking Connor Glisson for some very fine remarks today.